In this lesson, we begin our discussion on the various types of trusts. Now, this particular lesson is quite wide and there's a lot that we must cover, so it will be broken down into several segments. Firstly, we'll be discussing express trusts. Now, an express trust is ostensibly the major type of trust that you will encounter in your studies, or for that matter in practice as well. These are deliberately created by the rights holder, or more commonly known as the settlor, as we discussed earlier as well. Now note that an express trust is a type of trust that can only be created by the settlor, the person who is the rights holder. This is also considered or known as a declared trust. Now, an express trust can be created in one of two ways. Either by declaring himself as the trustee, as in the settlor declaring that he will hold the rights on trust, which means that the settlor is equivalent to the trustee. So for instance, an example would be A says he will hold property for B. The second, more common type is where there is a transference of rights to a third party. This creates these three actors that we discussed earlier on in this course, which are the settlor, the trustee, and the beneficiary, the three parties. So here, A transfers property in the name of C to be held for B. Now note that not every declaration is effective to create a trust. This mere hope or desire does not count. Now later on in this course, we will be discussing proving of such declaration, but for now, this would suffice. So the freedom of trust is basically within the confines of the law, whereas the settlor can make a trust that he wishes. Another type of trust is a fixed trust. Now before we proceed, you need to understand that these are types of trusts as much as they are characteristics of trusts. So you might have an express fixed trust or an express discretionary trust. The express component of it is that it has been created by a particular individual, by the settlor. The fixed or discretionary, as we will be discussing here, is basically a characteristic then of that express trust. So a fixed trust is where the trustee just follows the settlor's orders or the instructions. So it's quite clear cut. So the interests of the different beneficiaries are determined at the very outset. So the settlor might have created a trust outlining who gets what. Conversely, a discretionary trust is where the trustee has the discretion as to how the rights are disposed of. Now, this might seem to contravene the intentions of the settlor, but for example, what a discretionary trust does is, in an instance where, let's say, I have shares in a particular bank and I appoint R as the trustee to hold these shares on behalf of my students, and in a particular proportion, for instance, student A rather gets 25%, whereas student S gets 75%. Now this brings on to the component of the beneficiary. When and how does the beneficiary derive this benefit or the beneficial interest? For this purpose, we look at two different areas. One is contingent and the other is defeasible. In the context of a contingent beneficial interest, what it means is it's one which will only arise if a certain event occurs. The basic example here is when, for instance, a child turns 18. Defeasible, on the other hand, is one which may come to an end upon the happening of an event, for instance, death. So in a contingent event, it does not get activated until someone reaches a particular age or accomplishes something, so on and so forth. Whereas in a defeasible situation, the trust will be activated and it will be functioning until a particular trigger occurs, for example, the death of the beneficiary. Now that we have outlined a few particular types of trusts, in the next lesson, we will broaden our reach.